This podcast provides information to help esports professionals identify and approach legal problems. This podcast is intended for informational purposes only. Legal information is not the same as legal advice, which is an application of law to a party's specific set of circumstances.
You should not and are not authorized to use this podcast as a source of legal advice. And the information in this podcast does not create an attorney-client relationship between the Law of Esports podcast, any of the lawyers or affiliates of the podcast, and any consumer of this podcast.
Welcome to the Law of Esports podcast, the number one podcast that discusses legal issues as they apply to the world of esports. My name is Jake Hicks, and I'm an attorney that represents teams, leagues, and organizations.
And my name is Nefi Lopez, and I'm an attorney that represents players, streamers, and personalities.
And today we have a fantastic episode for you that discusses a little bit of the dynamics behind some of the ways that esports teams have found certain avenues to raise money, create a better customer experience, and overall expand what they offer to fans, customers, investors, etc. And that is cryptocurrency tokens and non-fungible tokens, or NFTs. Recently, crypto tokens and NFTs have presented a new way to raise money, promote your brand, and really create a new type of engagement. But these offerings aren't without certain pitfalls. And there's been a number of risks and a number of actual enforcement actions that have required us as attorneys to be more involved in the process. And that's what we're going to talk about today. And so, in addition to some regulatory issues and some diligence issues that you really have to pay attention to if you're going to get involved in one of these offerings, I think first and more importantly, we should probably address some of the criminal implications and other enforcement actions and some of the past problems that have happened within the esports and content creator ecosystem.
Yeah. And one of the important things that we want you guys to understand is recently Jake and I have noticed that a lot of organizations, a lot of leagues, a lot of teams, a lot of content creators and professional players are starting to get involved with NFTs and cryptocurrencies. And we want you guys to be careful and want you guys to be aware of all the implications that means. Every time you guys sign up or even think about tweeting, talking about cryptocurrency, I know everybody says it's not financial advice, but just because you say that, it cannot necessarily mean that that's the case. So let's talk about some big things that have occurred in the past that we should be aware of and may not be aware of, but you're going to be aware after today. The first one is Save the Kids token. I'm sure you guys are well aware of that particular situation that occurred around June, July of 2021. We had some pretty large content creators, some of the ones that are like FaZe K, Rice Gum, Face Jarvis, Summer Rae, Joel Morris, which is a UK-based YouTube academy called Xcademy, FaZe Nikon, FaZe Tico, and a few other people that were involved with Save the Kids token that ended up making the news for not so good reasons. So let's hear a little bit about that. In case you guys weren't aware, Save the Kids token was essentially an altcoin cryptocurrency that the goal was to essentially divvy up, cryptocurrency to make profit for people that were investing in the coin. And then a part of it, some of the portion of the profits would be donated to charitable organizations involving children. Okay, what ended up happening in this particular situation was that there was essentially a pre-sale with around 200 investors that were allowed to buy the coin early on before it was open to the public. Okay, and what Save the Kids did, which was smart on their part, very dangerous and risky for content creators and anybody else that was involved with it, influencers, was that they were the ones that were essentially left to do all the marketing and all the hype around the coin, which ultimately ended up driving up the value. And the issues that we saw with this particular Save the Kids was that their marketing team was very good. They went out, they said a lot of different things that sounded very good to the content creators involved, along with the people that were going to be investing into Save the Kids. One of the things that the altcoins operators were initially communicating regarding its ambassadors, right, the content creators, was that they weren't going to be paid by the tokens, the developers, and they weren't going to be given any tokens as a result of their involvement with the cryptocurrency. It later turned out that those content creators and those promoters, the influencers, were actually either given the tokens for free as compensation for being involved with the project, or they were basically allowed to purchase a lot of the tokens at a very discounted rate, through their initial pre-sale purchase. Now, ultimately, what ended up happening was it Save the Kids ultimately ended up going live, and people were able to buy it. Just within 4 hours of the altcoin launch, the token's price shot up almost 500% and immediately crashed back down to the initial price. Now, during that initial time, whenever it, skyrocketed, what happened was that, there was essentially a pump driven by the public buyers, right? Whenever it goes live, everybody goes in and buys up, which drives up the price. And then, and a lot of that, just so you guys know, was because the content creator ambassadors were, pumping it up. They were hyping up the coin. And then there was a big dump by a majority of the pre-sale investors. And they ended up obviously getting some pretty big profits as a result of that dump. That basically ended up happening, which wasn't supposed to happen. Part of the marketing team for Save the Kids essentially, had this, what they call anti-well provision, which is essentially like a little safeguard to prevent people from, selling the large portions of the cryptocurrency.
Anti-whale. Yeah,
right.
A significant holder
what's
of
a whale?
tokens. Yeah. So a whale would be someone that holds a significant amount of the outstanding tokens to the point that they alone can influence the price or the fungibility of the token itself. And so if you have some whales out there, which you may inevitably have, it's important to have those restrictions. And so what you either want is to have a system where there are no whales possible, where you control the release and output of the tokens, or have those whale prevention measures. Save the Kids represented they had both. And it turns out they had neither.
Right. And just like Jay said, because whales in the cryptocurrency world are people that have such large amounts or own so much of a cryptocurrency that their decision to sell could effectively have a large cause the price to fluctuate. In other words, if they sell enough of it, it could cause the price to plummet. Companies want to have anti-whale safeties in place. Here, according to Save the Kids, they admitted that there was some type of decimal issue with the transactional limit. So
basically the Save the Kids anti-whale provision was that no one person could sell more than 0.1% of the total outstanding tokens in a 24-hour period.
Right. And, sort of a lot of this stuff actually came to public with some excellent journalism by a friend of the show, Some Ordinary Gamers, or Mudahar, and CoffeeZilla, whenever they did sort of a deep dive into this particular show, which, Jake and I both watched those videos. And it's also worth watching.
I recommend that video as well.
Exactly. Yeah. I was going to say it's worth watching, you guys. I recommend you guys watch both of those if you want to get a more, a full picture of what happened. Now, CoffeeZilla alleges, in his video, that the anti-whale code prevented whales from selling again in a 24-hour period, but the code was changed when the coins went live. It basically went from a 1-day period to a 1-minute period, making it easier for the influencers to dump their tokens and run off with the money. CoffeeZilla basically also said that it changed from being a code that wouldn't let the whale sell off in less than 5 days to a code that lets you sell off in 5 minutes at launch. And then, obviously there was the whole thing with FaZe Jarvis. According to CoffeeZilla, he said that FaZe Jarvis sold 2/3 of his wallet within days of the launch, while FaZe K sold all of his tokens, which apparently was like 6.2 million, while promoting the token as a solid long-term investment for people. CoffeeZilla also discovered that there was, instances of some of those guys involved that they were doing the pump and dump activities, which everybody wants to be careful of. Essentially, since all of that happened, there was a huge fallout. You guys are all aware of it. A lot of those guys were either kicked off or suspended from FaZe. Some of the other guys that aren't involved with FaZe received some pretty dire consequences. Some were fired from their jobs. And, other guys just were shunned by the community, were, for lack of a better term, canceled. And it got to the point, actually, whenever we were talking to Mudahar, and it's public, so it's nothing secret. FaZe K actually threatened to sue CoffeeZilla over his reports on the issue, which is, kind of crazy for us as attorneys to hear, especially whenever a lot of these guys, especially Mudahar and CoffeeZilla, they support everything that they do. I mean, these guys have a full-on legal team, as we've heard, that, they hire lawyers to look over everything to make sure that they're, on the money whenever they're talking about a lot of these issues. And so, this is one prime example of an instance where, and obviously the Save the Kids guy also was involved, the Sam Pepper or whatever his name was, the developers, and they also dumped and ran with the money, and who was left holding the bags is the content creators. And this is what we're here to talk to you guys about, to be careful. There are other instances where, there's similar rug pulls. I'm sure a lot of you guys are aware of Ice Poseidon's rug pull with the CX coin. I'm going to spend a little less time about that just because it's very straightforward. The guy essentially hyped up this CX coin, which was another altcoin, a cryptocurrency. And as soon as it went live, the dude pulled out and made like $500,000 or sold $500,000 worth of cryptocurrency. I don't know what his actual profits were. Maybe they were in the six figures. I don't know. Everything went public and he got caught. And instead of, apologizing like a lot of the other guys and Save the Kids did, Ice Poseidon kind of doubled down, called investors idiots. And then early on, his feelings were essentially like, I'm not going to refund any of the money. Some of the quotes that he said was that he could give the money back. It's within his power, but he's going to look after himself and not do that. As a matter of fact, whenever he did his interview with Deserto, talking about those who lost money in the coin, he didn't really appear to take any accountability. He said things like, what are you, their dad? You're a streamer. You're not their dad. If somebody wants to gamble their life savings away like an idiot, then they're going to learn the hard way. They have to take some responsibility eventually. And then said things like it's a dog-eat-dog world. And so, which, as we all know, Ice Poseidon's career essentially fizzled out after that. His lack of accountability, people took it personally. And the people that lost money obviously took it very personally. And so, everybody has to be careful when getting into these situations. And so those are some situations that have gone public. But, not much has really happened apart from the public consequences, right? Of being canceled, of getting kicked off from the organization, losing your job, losing sponsorships, losing, the ability to stream. Ice Poseidon, I think, got banned from Twitch since 2017. And so he didn't really have a ton to lose, but still lost his entire career, essentially. There's also criminal implications. And these are the ones that we want you guys to be aware of. Before we talk about the civil stuff, you guys have to understand there's also criminal implications to, insider trading and committing fraud like rug pulls and things of that nature when it comes to cryptocurrency and NFTs. And so in case you guys didn't know, the FBI has a new task force called the National Cryptocurrency Enforcement Team, the NCET or NCET. And they're, essentially in charge of investigating insider trading, fraud, rug pulls, things of that nature. And so the NCET, along with the Offices of Security and Commodities Fraud Task Force with the Department of Justice, the DOJ, are in charge of prosecuting these kinds of crimes. And so one of the things that we're going to talk about specifically, in case you guys didn't know, was this guy that got arrested on June 1st of 2022 for insider trading. What happened in this particular case was that on June 1st, and I mean, this is a young guy. He's a 31-year-old employee from OpenSea. He was arrested and charged with wire fraud and money laundering in connection with a scheme to commit insider trading in non-fungible tokens or NFTs by using confidential information about what NFTs were going to be featured on OpenSea's homepage for his personal financial gain. I'm sure you guys are aware of what OpenSea is. For those of you guys that don't know what it is, OpenSea is essentially like, the largest online marketplace to purchase and sell NFTs. In violation, obviously, of the duties to trust and confidence that he owed to his employer, which was OpenSea, this particular defendant or potential defendant exploited his advanced knowledge of NFTs that would be featured on OpenSea's homepage for his personal financial gain. With the FBI and the prosecutors, the U.S. Attorney's Office, stated on whenever they made their public announcement of this arrest, they stated and alleged that as part of his employment, the defendant was responsible for selecting NFTs to be featured on OpenSea's homepage. Now, OpenSea, they kept it confidential, they kept confidential the identity of the featured NFTs until they appeared on the homepage. I'm sure if you guys are aware, after an NFT is featured on OpenSea's homepage, the price buyers are willing to pay for that NFT and for other NFTs made by the same NFT creators would typically increase substantially. Why? Because everybody's seeing it on the front page. You guys know on Reddit, when it goes on the front page, everybody sees it. And so the price goes up. And so what this guy was doing is that, you know, from around June 2021 to at least about September of 2021, this particular defendant, the employee of OpenSeas, used the confidential business information about what NFTs were going to be featured on the homepage to secretly purchase dozens of NFTs shortly before they were featured on the homepage. Now, after those NFTs were featured on OpenSea, the defendant would sell them at profits 2 to 5 times of his initial purchase. Now, to attempt to conceal the fraud, and this is where he thought he was being slick, an attempt to conceal the fraud, the defendant conducted these purchases and sales using anonymous digital currency wallets and anonymous accounts on OpenSea. Now, the FBI assistant director in charge said this as a warning to out there to all of you guys that are listening. In this case, the defendant launched an age-old scheme to commit insider trading by using his knowledge of confidential information to purchase dozens of NFTs in advance of them being featured on the homepage. With the emergence of any new investment tool, such as blockchain-supported non-fungible tokens or NFTs, there are those who will exploit vulnerabilities for their own gain, and the FBI will continue to aggressively pursue actors who choose to manipulate the market in this way. And the guy, you know, is charged with wire fraud, money laundering, all related to insider trading with NFTs, all of which has a maximum sentence of 20 years in prison. And so I know we're starting off to sort of starting off hot with some big things, but we want you guys to understand that this is serious and we want you to really pay attention to the rest of this episode. And so I'm going to kind of pass off the baton to Jake, because for you guys, if you don't know, Jake is actually the guru on these kinds of things. I like to think that I know what I'm talking about, but Jake is really the master. And so I'm going to hand it off to him, let him talk a little bit about, you know, what digital assets are and discuss more of the civil side, you know, like the SEC and things of that nature. So Jake, I'm going to pass it off to you to talk about a little bit more about what a digital asset is.
Yeah. And I just want to make it clear that if you pay attention to what all the stories that Nefi just had, all the cases that we've talked about so far, they're all from the side of selling or promoting a crypto coin or an NFT. If you're buying something, we have no opinion on that, right? We're not giving you financial advice. And so we're not going to tell you what's a good idea to buy. This advice is really, or this information, I guess, isn't legal advice, but we just want to give you an idea of what you should look out for. And that if you spot any of these things, you really need to consult an attorney, because these things are pretty sticky. And if you're looking at joining a project selling a coin or an NFT or a digital asset, that these are some of the considerations you have to look out for and engage an attorney to help you out with. And Absolutely. So the whole point of this episode is to demystify what a security is, what the regulatory framework is, because it can be a little bit overwhelming. But even the concept of a digital asset really isn't that hard to comprehend if someone just tells you what it is. And that's something that Nefi does regularly with his clients. Nefi, how would you describe a digital asset?
So a digital asset is basically an issue. It's an asset that's issued and transferred using distributed ledger or blockchain technology. I know these are big fancy words, but it's essentially things like virtual currencies, coins, you know, cryptocurrency, whether it's altcoins or actual purchase power coins, and then tokens that include non-fungible tokens or NFTs. Now, before we go any further, I want you guys to understand, I know you guys see a lot of organizations that are being involved with cryptocurrency and with NFTs. I want you guys to understand that these people have a large team of legal teams that are reviewing every single aspect, teams that consist of lawyers just like Jake that tell them about the ins and outs and the legal intricacies of working with these folks because of the potential civil and criminal implications of being involved with them. And so we just want you to understand not to take this these types of things lightly. Okay. And so, and the reason why is because there's a lot of different regulatory agencies that govern these digital assets.
Yeah. So when we talk about regulatory agencies here, we're going to talk about the regulatory agencies that have to do with selling or trading these tokens or NFTs. And so in looking at what governs the sale of a token or an NFT, you really divide a digital asset into one of two things. A digital asset is either a security or it's just a commodity. If it's a security, and we're going to discuss those definitions in a minute, but those are a little bit sticky when it comes to these digital assets. Securities are regulated by the Securities and Exchange Commission. That governs the issuance, registration, disclosure, sale, transfers of an asset determined to be a security. The fun part about this is that securities offerings and the SEC, the Securities and Exchange Commission, come from either the Securities Act of 1933 or the Securities Exchange Act of 1934. Those are the laws that we're still operating off of today. Now, there's been a bill by Senators Loomis and Senators Gillibrand in Congress called the Responsible Financial Innovation Act, the RFIA. If that's passed, some of these things will change. But for right now, this is what we're working with. A law from 1933 and a law from 1934. Now, if the digital asset is not a security, it's probably a commodity, right? The commodities are regulated by the Commodities Futures Trade Commission, or the Commodities Futures Trading Commission, the CFTC. So whenever you look at regulation of selling a crypto token or NFT, you're probably looking at either the SEC, Securities and Exchange Commission, or the CFTC, Commodities Futures Trading Commission. The CFTC enforces a law called the Commodities Exchange Act, or the CEA. And commodities are things that you would generally think of as a tangible item that holds value. A piece of gold, a piece of silver, a bushel of wheat, a barrel of oil. These are all commodities. And to the extent that you have futures, meaning that you have a contract that allows you to buy a bushel of wheat 6 months in the future, that is a commodities future that's still regulated by the CFTC. And so I know when we talk about futures and derivatives, a lot of people think about the recent Robinhood stuff of buying puts and call options. And those are regulated by the SEC, but that's because the underlying piece of that derivative is a security, right? So if you have a commodity or a commodities-based derivative, that's regulated by the CFTC. If you have a security or a securities-based derivative, that's regulated by the SEC. There are also some trade organizations that regulate how some of these things can be bought and sold and have some enforcement capabilities, but they're not criminal enforcement. So, for instance, the Chicago Board of Trade will regulate certain trading times, some trading volume issues, and some licensing issues. And that's if you're trading commodities on the Chicago Board of Trade, they'll regulate some of that. And that's more of a trade organization. By the same token, the SEC has what's called FINRA, the Financial Industry Regulatory Authority. That is an agency that works with the SEC and to help regulate some of the financial markets, how people are licensed, what they're licensed to do, how they can get their license. They'll also bring people in front of formal reviews if you risk losing your license to trade, those kinds of things. But FINRA is not part of the SEC, and the Chicago Board of Trade is not part of the CFTC. They're kind of separate things, but they work with each other. So we have the SEC and the CFTC. Importantly, a digital asset can be either a commodity or a security. Most of what I do and what Nefi has clients really look at carefully and get counsel if they really need it on this specific issue is if you're a commodity, you can pretty much buy and sell as you like. You can buy stuff, sell stuff, not a big deal. There are some rules. Obviously, you can't have rug pulls. You can't do pump and dumps. You can't insider trade and defraud people. But you don't have to file a whole lot of things with the CFTC to be able to sell a commodity, to be able to sell a piece of gold. Now, if you're borrowing money to buy and sell those, it's a little bit different. But generally, if you have a commodity, you can buy and sell a little more freely. If you have a security, there's a lot more that goes into it. And I know security is kind of a mystical, weird term in today's day and age because we hear it all the time and no one says what it is. It's really not that complicated. It's just that, unfortunately, in the crypto and NFT world, people will try and hide or maybe not understand that what they're selling or what they're promoting is a security. But really, the definition of security isn't that wild.
Yeah. And so both NFTs and crypto tokens can be designated as a security. And I know we talked about what a commodity is, which are things like gold, silver, bushel of wheat, barrel of oil, coffee, hard things that you can buy, sell, and ship. If you buy a bunch of barrels of oil and you don't trade them properly, guess what's going to happen? You're going to get a delivery of oil. And so, the term security, and I'm going to give you guys a legal definition. The term security is defined by Section 2, Subsection A, Subsection 1 of the Securities Act and Section 3A10 of the Exchange Act to include certain enumerated instruments like stocks and bonds, as well as investment contracts more broadly. Okay. A security is defined as a fungible, negotiable financial instrument that represents some type of financial value, some type of monetary value at the end of the day once it's traded into hard cash, although it's not always cash. And Jake and I had long discussions about this, which usually comes in the form of a stock, bond, or an option. Okay. Section 2A1 defines it. It says the term security means any note, stock, treasury stock, security future, security-based swap, bond, debenture, evidence of indebtedness, certificate of interest or participation, any profit-sharing agreement, collateral trust certificate. I got a few more things to add to that. Pre-organization certificate or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for a security, fractional undivided interest in oil, gas, or other mineral rights, any put, call, straddle, option, or privilege on any security, certificate of deposit, or group or index of securities, including any interest therein or based on the value thereof, or any put, call, straddle, option, or privilege entered into on a national securities exchange relating to foreign currency, or in general any interest or instrument commonly known as a security, or any certificate of interest or participation in temporary or interim certificate for receipt for, guarantee of, or warranty or right to subscribe to or purchase any of the foregoing. That's a long list, okay?
It's a big piece of legislation. Yeah.
Yes, and they add and remove things as develop. I guarantee you that definition of a security at some point, once Congress and the government catches up to cryptocurrency and NFTs, will add specific definitions of what is a security, which will curtail, cryptocurrency, tokens, things of that nature to fall into that definition. Okay. Now, securities can also take the form of a variety of things. And through case law, we have learned the type of assets that are generally recognized as security. Okay. You have to understand the law can sometimes be vague. And so you rely on the courts to sort of give you specific examples of what is defined as security. Okay. And so as attorneys, our job is to look at what have the courts considered in the past, use those as examples, and try to guess what's going to happen in the future. Okay. And so based on case law, we've learned that types of assets that are generally considered or recognized as securities are shares of a company, right? Notes and evidence of indebtedness, and investment contracts. Okay. In the crypto NFT space, whether an item is a security generally turns or depends on whether the item is an investment contract. Okay, Jake, what's an investment contract?
Yeah, an investment contract sounds like a pretty simple thing, but like Nefi said, if we turn to case law, because investment contract is such a general term, it's been defined through cases to help us understand a little bit better what it is. And in 1946, there was a case called SEC versus Howey, Howey.
Old Howey.
Old Howey. In that case, the courts essentially put forth a 4-part test to determine whether a instrument is an investment contract and thus a security that falls under the regulatory framework of the SEC. And that test is for an instrument to be a security, there has to be an investment of money in a common enterprise with an expectation of profit solely from the efforts of others. The court went on to say that that's regardless of whether the shares in the enterprise are evidenced by formal certificates or by a nominal or small interest in the physical assets used by the enterprise. What's crazy is that that's a case from 1946, and that is still the test that we use today, at least when it comes to investment contracts. As Nefi said, we also look at notes, because notes are considered securities in some cases. And that's happened as recently as February of 2022 with the BlockFi.
Yeah. And can you explain to us a little bit of what a note is for those that are wondering?
Yeah, exactly. Yeah. So in the BlockFi developers case, an opinion was issued February 14th, 2022, in which there were developers that had created what they thought was a pretty crafty instrument in which they would take your cryptocurrency, they would lend it out for other people to use, and they would pay you interest on the loan payments that people paid back. So they loaned it out and received payments with interest. That's generally a note. If I give you money and I ask you to pay me back with installments with interest, generally that's a note. If someone else is handling that note for me and paying me interest on top of that, that can be a note that, if freely tradable, would be a security, right? And so if you're trading those notes, that could be a security. BlockFi developers, they said based on that and a couple of other factors, which we won't go into here because that's a lengthy opinion, but if you're really interested, I suggest you read it, and I can link it on my Twitter. That we use that a bunch in determining whether something is a note. And even within that case, there are a few pieces of case law that were used. For instance, if you're Googling, look up the Reeves case, a big one in determining what is a note. Back to investment contracts. So an investment contract, an investment of money in a common enterprise with an expectation of profits solely from the efforts of others. The weird thing is, in the crypto world, a bunch, or at least most of the time, 2 or 3 of these elements are generally satisfied right off the bat. So an investment of money, basically, if you're paying money and getting something back, that's an investment of money. Yeah, that's an investment of money. Now, if you're performing labor for something and then you get paid in crypto back, that may not be an investment of money, but then you run into some other problems with whether you're actually paid to promote the product, and we run into that save the kids potential fraud issue, right? If you're getting something of unknown value. So if you're paying for crypto, you're getting it back, that's usually an investment of money. A common enterprise is also pretty simple, and that's generally a group of people that are operating towards the same path. And operating can mean either you're doing the work or you've invested the money for other people to do the work. Common enterprise, it's fairly common. And in crypto, obviously, you have to have people that create the token, that monitor the token, that create the platform for it. And so usually that prong is generally satisfied. With the expectation of profit, right? That prong is also usually satisfied because you hope that the token goes up. You don't have to expect a specific amount of profit to have an expectation of profit. That's pretty massive. So importantly, an expectation of profits alone doesn't mean you have a security, but you also don't have to have a specific expectation that what you just bought will increase in value. You just have to kind of hope that it does. And that's one of the reasons why you buy into it.
Right.
An expectation or an example of something that may not yield an expectation of profit is, let's say that Nefi has some issue where he's trying to play basketball and sprains his ankle and starts a GoFundMe, and I give money to his GoFundMe. I'm probably not expecting profits at all there, right? That's just a donation. Donations are not the same as investments. Even though he's my friend and I may be investing in our friendship, it's not an expectation of profits. But if I'm buying a cryptocurrency in the hopes that I can use it later and that I can actually get some value out of it, that's an expectation of profit.
Yeah. And Jake, if I may add, sorry, let me just add. And one of the big things, and which is sort of a hallmark feature of a security is, everybody talks about passive income. Here it's passive expectation of profits from the efforts of others. That is a hallmark feature of a security. And so that plays a major role whenever you're trying to make that distinction. Is this considered expectation of profit from the effort of others? Sorry.
No. And then the SEC came out with a release based on what they call a FinHub framework. And according to their FinHub framework, they said, quote, when a promoter, sponsor, or other third party provides essential managerial efforts that affect the success of the enterprise, and investors reasonably expect to derive profit from those efforts. So that's an expectation of profit from the effort of others. Okay. Importantly, and this is really important because I've had so many questions from clients on this issue if we just take our white paper or take our marketing materials and we say, look, don't expect profits from us or from our efforts. Doesn't matter. Okay. According to FinHub and the SEC, this analysis is objective. It's focused on the transaction itself and the manner in which the digital asset is offered and sold. So if you are creating an instrument and then you're going to do the work to increase its value, whether you're promoting it, whether you're buying a bunch of other assets to pump up its value, even if you say you're not doing it to increase the profits, let's say you're trying to get a bunch of people to promote it in order to increase the stability of the token. That's not what the SEC will look at in an enforcement action. They're going to look at the metrics of the transaction itself. Did you invest money? Did you get profit from it? Was it likely to provide profit, or was that the reason for your investment? And that's going to be an objective analysis. Doesn't matter what's in the marketing materials. Doesn't matter what's in the white paper. It's an objective test. And so you can't just put in your marketing materials that you're not going to rely on the efforts of others. It's really not up to your marketing materials, right? Generally, a commodity plus value-adding services can usually be considered a security. And so if you have a NFT that is a piece of art, but you promote it and you promote its exclusivity, you promote its general rise in value, and then you want to offer a series of those NFTs, that can be considered a security. That's why you have to be really careful when it comes to these NFT projects. And again, even if you say it's just art and you don't care how much it sells for, the SEC doesn't care. That's not what they're looking at. They're looking at whether you rely on the efforts of others. And that fourth prong of the Howey test is probably, in my practice, where we see the most struggle with platforms that want to offer NFTs or a cryptocurrency token without being a security, is a lot of times that fourth prong is the one they struggle with. Because if you look at things like, music NFTs, where you're selling the artist's song, or if you're looking at NFTs that evidence someone's like work or sports performance or something like that, and their continuing performance impacts the value of that NFT, then you're still looking at potentially a security there. And that's one of the hard issues to have to contend with. We have a client right now. We have a call tomorrow, and I can't tell you what the NFT is about, but essentially, if you sell an NFT and a person will get paid out more value based on the effort of a person represented by the NFT, that can be a security. Basically, another way that you can bring yourself out of the world of securities when it comes to cryptocurrencies is a decentralized autonomous organization, what's called a DAO. If you follow cryptocurrency at all, you'll probably understand what a DAO is, or DAO governance. And that is one way that you can essentially remove that fourth prong of the Howey test, right? If it's not solely from the effort of others, but everyone in a decentralized manner has some governance rights, then you may bring yourself out of the world of a security. The problem is DAOs are very hard to be completely decentralized. It's pretty tough. If you look at the Save the Kids example that Nefi spoke about earlier, that was essentially one small group of people that had control over the whale prevention system or the initial list of holders, or when the cryptocurrency was sold, how much was sold in the beginning. All of those things weigh against being fully decentralized. As it stands now, there aren't many cryptocurrencies that we believe are fully decentralized, or at least decentralized enough to not be a security. And so DAOs are important. But again, if someone comes to you with a crypto project and they say they have a fully decentralized DAO, you're going to want to see how they've analyzed that.
And Jake, if I can add a comment to that, in particularly in Save the Kids, there was a smart contract security audit by this company called TechRate, and Save the Kids, the altcoin had a little over 7,000 holders, over 19,000 transactions, but the top 100 investors held almost 78% of all outstanding Kids tokens. And at least that was the case as of June 5 of this past year. And so just to kind of give a little bit of background on Save the Kids, although there's 7,000 holders, over 100 hold almost 78% of outstanding, or did hold 78% of outstanding, a little under 78%.
Yeah. And when it comes to how I'm weighing how decentralized a DAO is, if I see anything over 40%, that's a massive red flag. Usually we want to see 20% or less by the original founding group. And so if it's 78%, that is a kind of a nightmare in terms of a regulatory scheme. But yeah, so anything over 40% is a major red flag. We like to see under 20%. And again, to do this, we have a proprietary analysis for the firm, for us as attorneys. So we can't share everything. And even if we did, it would take us 4 hours to do all that. Yeah. So there's a lot that goes into this, but I'm just giving you some things to look out for and to not be fooled by, because someone saying their crypto project is decentralized is so common, and it's often wrong. For the most part. And so you have to be pretty concerned. And so there's also a difference in kind of transactional tokens like Bitcoin and Ethereum, and utility tokens. And when you look at utility tokens, this is outside of altcoins like Save the Kids and other charity coins. But utility tokens are things like the Matic token on Polygon or the DAG coin on the Constellation Network. They are the coins or tokens that are used to facilitate projects on certain smart chains. And those generally, if they're just used to facilitate work on the network, they usually aren't securities. However, in 2017, we have the SEC coming in with what's called the Munchie Order, MUNCHEE, where they declared that just because something's a utility token, it doesn't mean it can avoid being a security. And again, they look at the economic realities underlying the token. And the only reason why Nefi and I keep on harping on this point is because if you're a content creator, if you're a team, if you're an organization, and you're approached with an NFT project or a crypto token project, you cannot just take the person's word for it. The SEC will not look, they'll look at the marketing materials, but that is not the end of their inquiry. The CFTC will look at the marketing materials. That is not the end of their inquiry. And you better believe the FBI and their crypto enforcement task force will look at the marketing materials, but that will not be the end of their investigation by any means. The economic realities of the transaction are vitally important. And so essentially, we've talked a lot about whether your crypto project or NFT could be a security. And now let's talk about why it matters if it is a security or not. Okay.
Now, before we do that, Jake, I kind of want to step in a little bit. So just to kind of do a little brief summary of what we talked about, right? Whenever we're doing this test, right, what we call the Howey test, okay? That's based on the SEC versus Howey 1946 case, right? And this is a definition of what is considered an investment contract or not, right? The four things we talked about, okay? The first one is an investment of money, right? In a common enterprise with an expectation of profits solely from the effort of others, right? Jake went into pretty good detail of investment of money and then expectation of profits and solely from the effort of others. One thing that I kind of want to harp on a little bit is a common enterprise, just to kind of give you guys a little bit of background on what that means, right? Real quick, a common enterprise can be three different things, right? It could be horizontal, narrowly vertical, or broadly vertical. Okay. A horizontal common enterprise exists when multiple investors pool their funds together and the profits of each investor correlate with those of the other investors, right? One example that Jake and I talked about early on, let's say you and your buddies get together and, let's say there's 5 of you guys pool your money together, right? And essentially the profits of each investor correlate with those of the other investors, meaning you guys are putting money together with the goal of making more money. That is what's considered a horizontal common enterprise. Now, a narrowly vertical common enterprise exists when investors' profits are tied to a promoter, right? If you have a promoter that, you're investing money, you're giving it to the promoter, that's called a narrow vertical common enterprise where your profits are tied to that promoter and the promotion of whatever it is you're investing in. And then there's a broadly vertical common enterprise, which is when profits depends on the promoter's expertise, right? And so those are the three: horizontal common enterprise, narrowly vertical common enterprise, broadly vertical common enterprise. We're not going to go into super more detail than that just because it's a little more complex. We would be here all day talking about it. Just guys know that those are the common enterprises. You can look more into it. And there's a lot of information out there. Just be sure that whatever sources you guys are looking into, Jake and I have done hours, and really Jake has done a majority of the research behind that. And then there's another common enterprise test, which is the risk capital test, which considers 4 things again, right? Attorneys, we like 4s. The risk capital test, which considers, first one, whether funds are being raised for a business venture; 2, whether the transaction is presented to the public at large; and 3, whether investors are substantially powerless to influence the success of a venture; and 4, whether the investor's money is at risk because it is not sufficiently secured. Okay. Another common enterprise test is the risk capital test. Okay. So remember, the Howey test is how you determine whether an asset is an investment contract. Okay. 4 things: investment of money, common enterprise, expectation of profit solely from the efforts of others. Okay. And so anyways, we were moving on now to talk about why does it matter if a cryptocurrency or a token or NFT is a security? Okay. The reason why it matters is because it brings your actions within the scope of SEC enforcement and requires you as an issuer to comply with certain obligations or meet an exception to them. Okay. What this means, right? Let me read that again. And Jake, do you want to add a comment to that?
No, if you're going to read it again, go ahead.
Okay. So it brings your actions within the scope of the SEC. Okay. And it requires you as an issuer. Okay. And that word is important, right? Issuer includes every person who issues or proposes to issue any security, and person includes any unincorporated organization as defined by 15 USC statute 77BA4. Okay. The term issuer is flexibly construed as issuers devise new ways to issue their securities, and the definition of a security itself expands. And this is based on the Doran versus Petroleum Management Corporation, which is a Fifth Circuit case from 1977. Okay. Therefore, if the tokens were security, then their identifiable issuer would be required to register offers and sales of the tokens unless an exception were available. Okay. What this means is that whatever project you're working with, right, even if you're just an investor, but more importantly, and this is where it matters, if you're a promoter, the reason why we're creating this episode is because as organizations, as leagues, as teams, as content creators, as professional players, the value that you bring to these people that approach you for these projects, the value that you bring in is that you are an influencer. You are promoting and therefore increasing the value or contributing to the value or the trade of this particular, what could potentially be considered a security. Okay. And so although you're not the developer, although you're not the direct promoter, as somebody involved in promoting or potentially, pumping or hyping a particular NFT project or cryptocurrency, you could be considered an issuer, which brings your actions within the scope of SEC enforcement. What that means is that could lead to civil penalties, civil fines, a lot of regulations, a lot of requirements, and obligations that include registration. And Jake, I'll let you take over at that point.
Yeah. So the reason why it's important if you have a security is because if you don't meet certain obligations, you will have an SEC enforcement action, which can include fines, could potentially include jail time. It can include a variety of things. It could include the fact that you'd be prohibited from ever offering a security ever again. And the more popular these projects are, the more people may want to do them. And you don't want to be precluded from participating in the game, right? And so if these are a security, if your NFT is considered a security, you have to abide by obligations. One is issuer is a very defined term. Nefi mentioned it at length. And that can be if you tweet about it, if you help promote it, you can be acting in concert with the issuer and you can have some problems there. You also have to comply with certain registration obligations, right? And the more that these obligations stack up, the more expensive it is to participate in the project. But the problem is once you start participating in the project, you either have to get out without and clear yourself of any further involvement or liability, or go through these obligation requirements, both of which are going to cost money for attorneys to figure out how to do. The registration obligations are pretty thorough. They're from the Securities and Exchange Act. Okay. And they're what you have to do. You don't really have a whole lot of options. If you fail to register and you sell securities or offer to buy them, and you haven't issued a registration statement, you're going to violate some parts of the Securities Act. Registration is not an easy process. It's not like you just submit a form that says, hey, my name is Jay Kicks. I'm going to offer a security on August 1st. Not really what's in there. Registration statements and the SEC registration documents are fairly thorough. They include things like detailed information about the issuer's financial condition, the identity and background of management of the organization offering the security, and the price and the amount of the securities to be offered. That's just a piece. There can include other things that essentially the SEC wants to see that material facts, this is quote, material facts bearing on the value of publicly traded securities and are central to the Act's comprehensive scheme for protecting public investors are there. That's also from a case from 1979. So this has been around for a while. The other important thing is that if you fail to register, that is a violation of the Securities Act, even if you didn't have any intent to violate the act. Right? Intent is not an element of failing to register. If you're charged with failing to register, it doesn't matter if you just missed it, if you skipped it, if you didn't know what you had was a security, there's no element of intent in that charge. And Nefi and I constantly are involved in fraud cases where intent's a big element. In the securities litigation world, that element isn't called intent as often. It's called scienter. Which is a element of securities fraud. You don't even need that, right? It's not really even fraud. It's just you failed to comply with the act.
Ignorance is not excuse of the law, there's a saying.
Yeah. So someone comes to you with a project. It meets the Howey test. It's considered a security. You participate in the issuance of that crypto token or those NFTs, and you haven't registered with the SEC and filed a registration statement. You violated the act. You're going to have to pay some pretty heavy fines, and you may be banned from ever selling anything like that ever again. You also have to sell it on an exchange, and exchanges are also heavily regulated. There's a number of pieces of the definition of what an exchange is. That's not really as important. If you're going to operate an exchange, then you should consult an attorney. If someone comes to you and they say, we want you to help us operate an exchange, don't even worry about this analysis. Just consult an attorney from the get-go. And that's pretty sticky in the crypto world because you have things like crypto.com and Coinbase, and they're kind of regulated like exchanges, but not really. We think that's going to change in the future. But again, if someone says they want to come to you to help them operate a cryptocurrency or NFT exchange, just seek an attorney out the gate, because that's going to involve a number of requirements, regardless of what the definition is. And I wrote them out here as part of this research. But if you are going to operate an exchange, you need to register with the SEC or have pretty strong research and pretty strong lawyers like Coinbase has to help you avoid some of those issues. But I hesitate to even give information on that because I don't want someone to fall into that issue. But okay, let's say that you do want to offer a security and you have to comply with regulation. Those regulations we just talked about will apply unless you meet an exemption. And so I was listening to the Optic podcast, and Nefi and I were talking about this before we started recording, where there was an episode, and I could not find what number it was, but Optic was sponsored by an NFT art website that sold art NFTs. And as part of the ad read that they were doing, they said, and please see this website for Regulation A disclosures and other investment confidence information. Regulation A is one of the regulations you can fall under if you meet an exception to the SEC registration requirements, right? So you have two regulations that you can fall into that require a little bit less in terms of disclosure and compliance. One is Regulation A. The other is Regulation A+. The hard part about this is when I first started working in this space, people don't say Regulation A or Regulation A+. They just say Reg A or Reg A+. I thought they were talking about an advanced type of Jamaican music. Turns out they were talking about Regulation A. So you have Reg A and Reg A+. And so Regulation A is an exemption from registrations for public offerings. And Regulation A has two offering tiers. So tier 1 is if your offerings are up to or do not exceed $20 million in a 12-month period. And then tier 2 is for offerings that don't exceed $75 million in a 12-month period. If you're right at like 20 million, or if you're getting close to that, you can pick tier 1 or tier 2. What I tell clients is if you're offering $18 million, but you could end up offering a little bit more, go for tier 2. You don't want to mess around with those amounts, and you don't want to go into a second tier if you're only prepared for the first tier. But there are certain basic requirements for both. So you have to be eligible as a company. There can be bad actor disqualification provisions. There's some disclosures that are required, maybe not the same length as in standard SEC regulations. And then if you are in tier 2, there's additional limitations, like the amount of money a certain investor can invest, and then also audited financial statements and filing of ongoing reports. And those are both in tier 2. So tier 1 isn't as much trouble. There's some requirements for sure. Tier 2 is a little bit more. And then if you're outside of tier 2, you are back in regular SEC territory where you have standard comprehensive filing requirements, meaning if you're offering a security and there's a notable event that impacts the value of your company, you have to file an 8K with the SEC. Every quarter, you have to file your quarterly reports, or 10Ks if you're offering new securities. You have to file S1s if you're offering a new round. There's a whole list of SEC filings you have to comply with, and it's time consuming. And because it's time consuming, it'll make your lawyer spend more time and you'll have to spend more money. But if you're offering something under $20 million, then you might fall under Regulation A, and it's not all that scary. So just because you're considered a security, if you have the right legal counsel getting you within the right framework, you can still be able to successfully launch your project, successfully launch your NFT, and stay in compliance without spending quite as much money. And we've done projects where we've had clients comply with Regulation A. It's not a problem. Regulation A+, not a problem. It's a little more money, but again, if you're confident in your project and you have the right legal counsel, you're probably going to be okay. The last thing that I wanted to mention is some of the risks in cryptocurrencies that we usually see. And again, this isn't to buy them, but if someone comes to you with a project, these are things you should generally look out for to see if the project's even legitimate in the first place.
Yeah. And before we get into that, Jake, before we get into that, we just want you guys to understand that you have to understand the analysis that we're giving you guys is very cursory, right? That means we're basically giving you about 1 hour worth of information on a very complex, a very novel issue. Okay. One thing that I want you guys to understand is nothing that we've told you obviously is legal advice. Nothing is financial advice. Whatever we're about to give you right now is in regards to the risk or things that we've learned from dealing with past clients and research that we've done. Nothing that we say is perfect. Nothing that we say is going to save you or bring issues in the future. And so you shouldn't rely on it to the fact instead of basically using this episode and this information we provide in lieu of getting legal advice. Okay. Anything involve money there's going to be somebody that's going to want to get their hands on it to make sure everything is kosher and make sure everything is okay. Okay. And so you guys need to understand that we aren't giving you every piece of analysis here. I know Jake is going to sort of reiterate that fact, but I want you guys to understand that what we're giving you is not financial or legal advice, and it's not everything. Okay. If you guys are dealing with a project, seek your own legal counsel and get specific advice. We're going to talk. We're going to close up with that sentiment again. And so I'll hand the baton back over to Jake. But before we talk about these risks, I want you guys to understand that it's not everything. Okay. There's a lot of unique issues to every specific. I mean, it's very case specific and very project specific. So these are just general risks and the reliability of cryptocurrencies.
Yeah. And we have, like I said, we have a proprietary analysis that we've built over time. And I'm sure a lot of other firms do, a lot of other attorneys do, but it's pretty lengthy and it can be a lot of pages. I think our outline just to talk about this today was spanned multiple pages and had a lot of information, a lot of case sites, all that. But generally, if you see a crypto project, there's a few things you want to look out for. Basically, is it a project that's supported by the Ethereum or Binance blockchains? So is it an ERC20 or BEP20 token? I know there's other blockchains out there that are getting more and more notable, like the Polygon blockchain, but we still like to see Ethereum or Binance. Has it launched yet? Is it launched on mainnet? If it's not even launched, then you have a whole slew of issues because so much can change between concept and launching on mainnet. Has it been offered to people in the U.S. or only to non-U.S. persons? Because remember, people outside the U.S. aren't regulated by the SEC, right? And so if a company is trying to avoid that, they'll offer it to people only in foreign jurisdictions at first, and then try and swindle in some U.S. persons that fall under the regulation. Also be careful about that. Is it held by a few people or hundreds of thousands? Remember, I said 20% is kind of what we look for, 20% or less. But if it's only held by 5 people and one is a founder, that meets the 20%, but it's not really decentralized and not really what we're looking for. Does it give dividends or other distributions without having to do anything? Are people hyping the token on Twitter or on Reddit or on other websites? Especially people who haven't bought the token or who you can see or are not talking about how they bought the token or NFT. That's a problem. And so that's a few things that we really look out for. That list that I just mentioned, I mentioned 5 things. Our list is about 36 things, and each of them have little subparts. And so just be careful. But that's a few things to look for kind of from the get-go. And again, I just came back from NFT NYC in the NFT conference in New York, and we were one of the only law firms, or I was one of the few lawyers that was even there at the conference. And most people that are offering these projects are much more concerned with how to market it, how to keep it stable in an unstable market, and how to be a successful project. There are much, much fewer people that are concerned on the back end on the legal side. Because remember, the SEC may not enforce their framework and may not come down to you with fines for years after you initially sell your token. There may be an enforcement action right now. They've opened up an investigation into Binance based on the launch of their token from 2018. And here we are in 2022. And the SEC just announced they're investigating the launch of the Binance BNB token in 2018. And so just because there's not a bunch of enforcement actions right now, or because a project has been going on for a year and there hasn't been an enforcement action, doesn't mean that it's completely safe. it doesn't mean that it's not going to get an enforcement action in the future. These are things that you really have to look out for if someone approaches you to be part of a project.
And if I can add to that, Jake, along with making sure you guys are getting competent counsel, another thing for risks. Whenever I talk to any guys that are coming to me and say, hey, Nefi, these guys pitched this idea to me. They want me to promote it, boost it. They're paying me, 20, 30K a tweet, or to make an Instagram post about it, or to talk about it on my podcast, or things of that nature. One of the big risks also, which is very, very common in this particular field, is the anonymous nature of the developers and the people that are creating these projects. If somebody approaches you with sort of some type of veil hiding their identity, where country they're from, who they're working with, names, things of that nature, you want to be careful. That should be an immediate red flag. If you don't know the people that you're dealing with, that's a problem. Okay. Because let's say, a lot of the issues that we've seen lately with these cryptocurrency and NFT scams or rug pulls or all these issues that we're having is the guys that are always left holding the bags are the content creators, are the influencers, are the teams or the organizations that have everything to lose. And so you guys have to be extremely careful, because the other guys have really nothing on the line, maybe some money, but you guys have your entire careers. You have your entire reputation. You guys have everything to lose. And so you have to be careful who you're dealing with. I mean, if you take anything out of this episode, is be aware and educated as to the deals that you're making. Okay. There's a lot of things happening right now that you guys have to be careful. One thing you have to understand is the law and the government is always behind. Okay. What that means is that just because you make a deal now and you don't get in trouble tomorrow doesn't mean that you're out scot-free. The government, like Jake said, with the BNB investigation, could take years. Okay. And the government essentially gets to decide when they want to prosecute you or not. A lot of these issues, because they're so novel, there really isn't a statute of limitations, which means there isn't like a yearly cap as to when they can come out, because they don't know how to define what these violations are. And so you guys have to be careful. Okay. As influencers, you have the responsibility. I know there's a bit of an ideological difference between people, any of the guys that I work with, any of the guys that I help, guys and girls. I always tell you guys as influencers, you have a responsibility to your viewers. Okay. Whether they're children or adults, you guys influence everybody. And I know I'm going to catch some grief on this, because it's not your responsibility to necessarily be the keeper of all these people, but you guys carry influence. That's why the term influencers is used. And so you have to make sure, because your reputation is everything, that you're dealing with people that are going to take care of you. If they don't tell you what their name is, if there's some shady things going on, if they're dealing with a bunch of foreign folks and not, any NA based people, you could potentially get yourself in some hot water that could eventually lead to you either getting canceled, getting dismissed from whatever organization you're a member of, or potentially lose other sponsorships. And so we use this as a forewarning to you guys listening. Okay. Be careful as to what you deal with. We had that very good episode with Mudahar, who's a very business savvy guy and is very familiar with this particular field. I mean, you guys go watch his YouTube video on Save the Kids. I mean, the guy has done his homework, and a lot of the sentiments that we shared are the same, which is good, because obviously we understand this stuff as attorneys. It's our job to understand it, because we advise our clients regularly on these issues. But to him, as a content creator, somebody that has amassed millions of followers, understands the reach and understands what he has to lose. And so I want you guys to understand 20, 30, $1 million bucks. That sounds like a lot of money, but you have to understand that you have the capacity or the ability to make money in the future. Don't shut that down for a price. Okay. Be smart about your offerings. Be smart about your deals. Be smart about what you promote. Okay. Be smart about what you put on Twitter. Be smart about what you put on Instagram, Facebook, YouTube. You guys have to be careful. And this is our PSA on this particular topic, which is NFT and cryptocurrencies. You guys be smart about who you're dealing with.
Yeah, 100%. And remember, as you're out there engaging counsel, these things are tricky, and you're a good outside counsel won't tell you can't do something. They'll tell you how to do it the right way. And I think that's what is important here, is that no matter, even if you fall under SEC enforcement or whatever, even if you're part of a project that's a security or not, knowledge is the best thing. Knowing what you're dealing with and how to do it the right way. If it ends up not being the project for you, so be it. At least you knew enough to be able to make the informed choice. And so we gave you some things to look out for. And if you see some of these things, definitely talk to a qualified attorney. And again, be careful. And there's ways to do all this stuff, and there's the right way to do it. And that's what we want you to be able to have the tools to do. So, I mean, again, Mudahar's video, super enlightening on how all these things can go wrong. And if you guys have any questions about anything we just talked about, because we blazed through a pretty big amount of information,
a complex subject.
Reach out. Yeah, please reach out on Twitter at The Law of Esports, at Nefi Lopez Law, and at Jake Hicks Law. If you have any questions about what a DAO is, the Howey test, if you want to read the BlockFi case, the Reeves case, you want to see what Regulation A actually requires in terms of a list of specific things, reach out to us on Twitter, and we're happy to share those cases with you, or, point you to the right regulation that you want to see, and talk to us. And if there's a big enough commotion for any one of these pieces of information, maybe we can dial in and do an entire episode just on that.
Yeah.
But if you guys don't reach out, then we don't know.
Yeah. Yeah. So thank you everybody for listening to this episode. Hopefully it was enlightening. I know it was a little complex, and I know it's probably something you may not directly deal with, but if you ever run into these issues, we want you guys to be educated. Reach out to competent counsel. And as always, we're here to provide you guys with the information. And again, shout out to CoffeeZilla and Mudahar, also known as Some Ordinary Gamers on YouTube. Those guys have provided some real groundbreaking work on their YouTube videos. And so we're going to shout them out, because we did watch their stuff, and obviously we're fans, but those guys are doing the real legwork, time, an effort that Jake and I just, we obviously could invest it, but our time is probably a little more valuable elsewhere. So we're happy to have those people there. For all of you guys listening, we do have a lot of more interview schedule in the future. We've got some big plans coming out. We've got some events that are going to be coming up that we're going to be talking about. We've got some big episodes that are going to be coming. We still haven't released any contracts episodes. Those are going to be coming. We're waiting for the right time to release those. We want to make sure we get as many listeners listening to the information that we're provided, and viewers watching, these videos, because we want to make sure that they fall on some ears that need to hear it. And so thank you guys so much. Follow us on all socials, Instagram, TikTok, on YouTube. Again, we've launched YouTube. We've sort of done a revamp of our YouTube channel. We're still working with some graphic designers to get our banners and everything together. Those are going to be hopefully up soon. But thank you guys so much. Follow us on Twitter. Follow us on all socials, on YouTube, at The Law of Esports. Thank you guys so much for listening, and we will see you on the next episode.
Thanks, guys.